Admiral, good morning. My ladies, my lord, I appear...
Yes. Mr. Clayton, before you begin,
I'm so sorry.
and even before the formal introductions, the court needs to say a few things. The first is that there is an anonymity order in place, and that says that pursuant to the court's inherent jurisdiction, sections 4, subsection 2 and 11 of the Contempt of Court Act 1981 and section 6 of the Human Rights Act 1998, there is an order that publication or other disclosure of the identifying information as defined in the schedule to the order shall be restricted to the extent set out in paragraphs 2, 3 and 4 of this order for the period specified in paragraph 5. For the purposes of the order, the identifying information means the names of the appellant, the third respondent or fourth respondent to the appeal, or any other information that is likely to lead to the identification of any of those individuals as being a party to this appeal. The restrictions are: the identifying information shall not be disclosed in open court. For all purposes in these proceedings, the appellant and the third and fourth respondents shall be referred to respectively as the father, the mother, and the child, or G. The witness statements, exhibits, skeleton arguments, and other documents contained in the appeal bundles, which contain the identifying information, shall be used for the purposes of these proceedings only, and shall not be disclosed or used for any other purpose, and shall not be provided to a party, even if referred to or read in open court, provided that the paragraph shall not require any amendment to existing pleadings, witness statements, or other documents that came in existence before the date of the order. No person shall be regarded as acting in contempt of court in respect of any disclosure of identifying information in the course of the hearing of the appeal that is accidental or inadvertent, and nothing in this order shall restrict reporting of anything said in open court unless the court has so directed. Subparagraphs 4 and 5 say that no person shall publish any identifying information in connection with these proceedings, and the restrictions in paragraphs 2, 3 and 4 shall last until the judgment on the appeal has been handed down or further order in the meantime. Now, the only other part of the order that I should deal with explicitly is that the appeal will be recorded by way of video recording, but will not be live streamed during the hearing. Thereafter, the completed video and or audio recording shall not be made available to the public without further order of the court. Now, as I know all counsel appreciate and other people in court need to appreciate, the purpose of this hearing is to determine whether or not certain information should be made public, and for obvious reasons, if it were to be made public in court, that would subvert the whole purpose of this hearing, as well as be contrary to the order that the court has made to protect the integrity of these proceedings. Therefore, we obviously anticipate and expect that counsel and all others in court will obey this order, and in the event of any inadvertent mention, we will immediately, if it's drawn to our attention or otherwise, make an order to cover the publication of it to prevent any matters being dealt with which should not be dealt with or made public. Now, for this purpose, this covers any tweeting that is made in court by any journalist who is present in court. So those who are live tweeting for the purposes of journalism obviously have to be conscious of the order that the court has made. Mr. Clayton, I interrupted your your introductions, but one other thing to say before you begin, which is that I hope that all parties have received copies of two authorities from the court this morning, that is Rhodes and Kuja, which the court considered might be material to some of the issues which need to be discussed. And the final thing to say is this. I note that there have been some ancillary matters raised. The purpose of the hearing today, for which we have a timetable from the parties, for which many thanks, is to deal with the substantive matters that are raised in the appeal and no other matter. If there are other matters which need to be dealt with and they require an oral hearing, that can be catered for, but that's not the purpose of today's hearing, which is to deal with the matters for which permission to appeal has been given. Thank you.
Thank you very much, my lady. My ladies, my lord, the people who appear before you this morning are these. I appear with Mr. O'Reilly on behalf of the appellant. Mr. Farmer represents himself in person. Dr. Proudman represents mother. The guardian is represented by Ms. Fottrell, Queen's Counsel, and Timothy Bow. And of course, you have the two interventions as well. The second point I wanted to raise is may I express our gratitude to the court for referring us to two authorities. Unfortunately, I haven't had a chance to read them properly because I only got them on an iPhone. So I wonder if I could look at them over the short adjournment, and I will be very short, but I just haven't had the chance to digest it as yet. And the third point I should mention, I think, before developing the submissions, is that I think that Ms. Reid had a query about the anonymity order, which so I'll let her develop that if I may.
Very briefly, it just relates, my lady, to the extent of that part of the identifying information which is less clearly defined, that which would be likely to lead to the identification of either of the parents or the child in this case. Can I ask the court to turn to page 236 so I can refer to this obliquely without breaching the order in exploring the issue? Page 236 of the core bundle, the court will find paragraph 16 of the skeleton argument I have prepared for the hearing below. It sets out a fact, and I want to clarify if I can whether the advocates can refer to that fact. I'm looking at paragraph 16A. And again, if I can refer obliquely to both the facts in 16A and the mechanism by which that situation came to pass, I would like to be able to refer to those elements of the factual background in the course of submission.
16A.
16A on page 236.
Why?
Because, my lady, a substantial part of the public interest in this matter being reported lies in that particular element of the factual background. And it's very difficult for advocates to grapple in a clear way with why that matters without being able to revert at all to that part of the factual.
Yes. I mean, before we deal with the substance, of course, the position is that this order was provided to the parties some days ago now, and nothing was said by you or on behalf of your client about its terms or its implications for the hearing. The time to have raised this matter would have been then, but we will deal with it in any event. Does anybody else wish to say anything?
Well, with respect to my friend, in our respectful submission, it's not necessary to do that. I realise now that it may be necessary to just deal with things by asking you to read passages, but that's as far as it goes. It doesn't seem to require it to be publicly stated.
We'll rise for a moment, thank you.
Yeah, yeah.
Thank you. So playing boss at that.
Sorry?
Playing boss.
This is instructions.
No, I know it's very distracting.
I think it is. Sorry. Another one bites the dust.
Mr. Clayton didn't introduce us as the other first responders. I'm sure he's
All rise.
Ms. Reed, your application is refused. We don't think it's necessary for the matter to be referred to in open court, and reasons for that will be given in the judgment, which will be handed down.
My ladies, my lord, we have reduced our submissions to writing, which I hope will facilitate getting through this in good time. I wonder if I might hand up a speaking note.
Have the other council been given copies? Have you got copies for the other?
I do have
council?
copies. Yeah.
All right. So hand it in then.
Could you hand them? Sorry. There's plenty there.
Yes.
My lords, my ladies, the first paragraph, you can ignore, that simply sets out the issues that fall for determination. The second paragraph is important. It's the first ground, and it's really about the likelihood of the child being identified. And can I ask you to read to yourselves paragraph 2.2?
Yes.
We would respectfully submit that as a matter of common sense on the particular facts and circumstances of this case, that identifying mother and father is highly likely, if not inevitable. And in making that point, we would respectfully submit that the fundamental question posed by this appeal is whether the inherently uncontrollable and unpredictable nature of publishing judgments, which could have obvious and immediate direct impact on child's rights, is justifiable on Article 10 grounds, as the learned judge found. And in that regard, can I draw attention to some submissions advanced by the Association of Lawyers for Children? Can I just take you quickly to them for purposes of reference? It's to be found in the supplementary bundle. If you could turn, first of all, to page 107 of the supplementary bundle. and it's just for context. If you could look at page 107 refers to the association jointly commissioning and funding research.
Sorry,
that-
Mr. Clayton, would you be kind enough to refer to paragraph numbers? 'Cause
I'm so
I
sorry, I
don't
said
have
paragraph
any
20.
pagination.
Paragraph 20 at page 107.
Paragraph 20, thank you.
It refers to research conducted, and I just want to introduce that by referring you to the actual fruits of that research. If you could turn to page 108, paragraphs 21 through to 23, which draw attention to the fact that children find identification through the internet to be troubling or worse. I mean, it speaks for itself. I don't paraphrase it. I just rely on that, drawing attention to the fact that this has potential consequences. I don't think I need to say anything more about the first ground. It speaks for itself. It either commends itself to my ladies and my lord, or it does not. The next point I want to deal with is what I'm going to call the Section 97 point, which involves the Section 3 of the Human Rights Act interpretation propounded by Mr. Justice Mumby, as he then was, in the Norfolk County and Webster case. And as we indicate at paragraph 5, this raises really 4 separate questions. First, whether the father is entitled to raise a submission before the Court of Appeal. Secondly, the proper construction of Section 97. Thirdly, the limitations on statutory interpretation under the Section 3 of the Human Rights Act. And fourthly, whether Mr. Justice Mumby's interpretation is correct. Dealing with the first question, whether the father is entitled to raise the Webster submission before my ladies and my lord, the court will, of course, be very familiar with the principles set out in the White Book at 5221 1.1, and I'm not going to take you through them because they're well known to you. But what I have done, and I've done this throughout this note, is cut and pasted the relevant passages, so it's a standalone document. That was the intention of doing it in this way. And what I've done is refer to 5221 1.1, and where the White Book cites the relevant principles as those stated by Lord Justice Haddon Cave in the Singh and Das case. And if I could just invite you very quickly to read paragraphs 16, 17, and 18, which are the ones actually cited in the White Book.
Yes.
And then at paragraph 8, what I wanted to do is indicate that we satisfy the conditions enumerated by Lord Justice Haddon Cave in paragraph 17 of that judgment, in the sense that the Section 3 point does not necessitate any new evidence. Raising the point would not have resulted in the trial being conducted differently with regard to evidence. Of course, we're not here concerned with the trial at all, and the parties are adequately protected in costs. We also submit that father satisfies the conditions set out in paragraph 18. The other parties have had adequate time to deal with the point. The father's skeleton was served as long ago as the 19th of August. Various skeletons show the parties have not acted to their detriment on the basis of an earlier omission to raise it, and the parties are adequately protected in costs. And as we indicate in paragraph 10, the principles are accepted by the guardian in her submissions. The guardian, however, raises the point or reasons why the point wasn't raised before the learned judge. And the reasons that occurred are those set out in paragraph 12, which I should briefly address. As stated in father's second skeleton argument before the learned judge, the leading counsel was instructed because submissions were advanced which were outside the scope of junior counsel's experience. Then can I invite you to read paragraph 2 to yourselves? Actually, I'd invite you to read subparagraphs 2, 3, and 4 to yourselves, please.
Yes.
Then 5, the decision in Webster did not figure prominently in the submissions made before the learned judge, apart from a passage quoted in Miss Tickle's skeleton when I given the relevant citation from the core bundle. And the judge herself, in her judgment, discussed Webster in paragraph 15 and the judgment of Sir James Mumby, the President, in Re J, which referred to his earlier judgment. And then 7, and this is the important thing, I'm afraid, Father instructed counsel to appeal, we carefully scrutinize the judgments, and amongst other reasons, form the view that what Section 3 interpretation in Webster was, with respect, incorrect. We next make the point that none of the respondents address the father's point of substance or make any submissions as to the correctness of the Section 3 interpretation. That, with respect, speaks for itself.
Well, is that right? I thought that the mother has a section of her skeleton argument.
Well, sorry, there is they don't deal directly with the. I'm not going to quibble with that.
Well, the proposition is that your argument is misconceived. It seems to be pretty direct.
Well, there is a distinction which I'm about to make between broad comments about what the scope of Section 3 is, which I don't cavil with, and what the limitations of Section 3 are, which is the point of the submission I'm going to advance. If I've expressed myself infelicitously, then I shoulder that blame. The fundamental point we want to make, and as such is the very, very next paragraph really, is there is a distinction to be made between broad points about Section 3, which are very well known, and problems about whether they're on point. And the next point I want to raise is this, is the correctness of Webster raises issues of general public importance. That's the first point to make. And the second is, it's important for my ladies and lords to have in mind Lord Newburger's approach in the Willers and Joyce case. Now, Willers and Joyce, you may remember, was a case about whether a Privy Council decision was binding on the law of the courts of England. But in the course of dealing with that, Lord Newburger dealt with authority and its effect at various stages. And he makes the point that as far as the High Court is concerned, QD judges are not technically bound by their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there's a powerful reason for not doing so. And I make that point simply to say this, assume for the sake of argument, and this is an assumption I accept, assume for the sake of argument that Webster is wrong for reasons that I will demonstrate. In our submission, it is important that the court address that. And if you likewise, if our submission is wrong, it's also important that it's addressed in our submission. So those are the points I make about how it came not to be raised. I can't do any better than I explain it. I think I could say at least this: the hearing before Mrs Justice Lieven was quite lively. The learned judge asked many questions in the course of submissions, which are absolutely right. But at no stage did the Webster issue really come to the fore. Now, the first point so I'm going to assume, and obviously I'm just assuming for the sake of argument, that the court is prepared to entertain the application as to whether Webster is correctly decided. And the first point I want to make is what is the proper construction of Section 97 taken without looking at anything else. And the starting point, as Guyton Mendoza says, is you look at the statutory provision itself. And I set it out at paragraph 18, which you can see for yourself. And it's really 19 in our submission, which is important. We submit the plain meaning, to use the language of Lord Newburger in the Williams case, which we cite in our skeleton, is that Section 97.2 is an absolute prohibition against publishing to the public at large, or any section of the public, any material which is likely to identify the child. That, we say, is a matter of plain meaning, is what Section 97.2 is designed to do. The important point for the purpose of this appeal is what is the function and role of Section 97.4. And in our submission, it's important to appreciate that Section 97.4 is the sole exception and to the absolute prohibition, and it comes into play if and only if the court is satisfied that the welfare of the child requires dispensation with 97(2). And we make the point, really, that two really which are related, that Parliament chose to enact an absolute prohibition against publication under section 97(2) with only one defined gateway. And the very limited scope of that gateway, paragraph 21, focuses exclusively on the welfare of the child. And that, with respect, is important because the welfare of the child is obviously a foundational principle of the Children Act, for example, section 1. And accordingly, in our submission, the welfare principle must be treated as a cardinal principle in the Children Act for the purpose of section 33 interpretation, in much the same way as in Re S Minors, the care order implementation of the care plan, which my lords and ladies are probably very familiar with, where the House of Lords held that a cardinal principle of the Children Act was that courts were not empowered to intervene in the way local authorities discharge their parental responsibilities under final care orders for the purposes of interpreting the statutory provisions in accordance with section 3. To remind my lords and ladies about that case where the leading judgment was given by Lord Nichols, was about the Court of Appeal introducing effectively a starred system to the way in which the local authorities should deal with children. And the House of Lords overruled it on the basis of saying that a fundamental feature of the RES was that non-intervention by the courts. As a result, it breached the cardinal function of the Act, and therefore it was impermissible as a Section 3 interpretation. I'm going to develop this submission in slightly more length in a minute.
Yeah,
but
I think you'll probably need to.
Oh, okay.
I mean, RES, the whole point about RES was that the Children Act had given the local authorities absolute control of the care plan once a care order was made.
Yes.
And the courts had slipped into the understandable but impermissible habit
Yes.
of starring certain aspects of the care plan, which they said could not be changed, or they had to come back to the court
Yes.
before they could change them. And what the decision was, no, you can't undermine Parliament's intention, namely that the local authority should have sole control.
I mean, RES is the most striking, although there are other examples. It's the most striking example of what the limitations of so far as possible is. I'm going to address that in the next section, but I just wanted to deal with the issue as a matter of what the meaning of the language is taken absent section 3 is, first of all. And we also make the additional point about the breadth of the section 97 prohibition shows its centrality to the Act for the reasons that are set out at more length in section 23. And then we come to the heart, really, of this appeal in respect of section 97, and it's this. Section 3.1 expressly identifies the limits of its ability to secure a convention-compliant interpretation, by using a language so far as it is possible to do so. It's very important to appreciate why section 3 was introduced in the way that it was and what the effect of it is. I'm sorry to say trite things, but obviously it's quite important. Parliament could have chosen to enact legislation which allowed the convention rights to trump legislation in every instance. And there's an interesting discussion of that in Guidon by Lord Millett about having effectively constitutional provisions which mean that legislation has to bow to constitutional rights. It's quite familiar in other jurisdictions. That is not the law in this country. It's also worth noting that the Labour Party's original proposal to incorporate the convention had in mind precisely such a scheme. It was a Canadian scheme of the Canadian Charter of Rights and Freedoms, and the Labour Party abandoned that. And they abandoned that for the reasons which are explained in the white paper, which accompanied the Human Rights Bill, Rights Brought Home. And can I just ask you to read, please, paragraphs, the quote, paragraphs 211 through to 213.
Yes.
So, it's probably more than a submission. It's actually fundamental to the Human Rights Act. Is the section, paragraph 27. Section 3.1 was designed in terms. It was intended to preserve the principle of parliamentary sovereignty and to introduce a powerful rule of construction. No debate about that. It's a strong rule of construction. That's very clear from Guiding Mendoza, amongst other things, but only so far as it is possible to do so. And our submission to my lords and my lady really comes to this. I'm going to develop legal principles and support, is what you can't do when you look at a statutory provision under Section 3 is rewrite the provision. Rewriting is impermissible because it breaches the principle of parliamentary sovereignty. What you can do is read it in, add it in. For example, the rape shield case is a famous example of that. What you can't do is rewrite it. And what has effectively happened, we would respectfully submit, is there's the statutory scheme envisages one and only one gateway through which the prohibition can be overridden. One and only one, and that involves the welfare of the child. And I'll come to the Webster decision in more detail in a minute. But with respect, as a matter of principle, it is clear that you are going too far if you are basically ignoring a statutory scheme and saying that the convention principles can somehow be read into them. That is a line which you cannot cross, and it's a line which you cannot cross for a number of different reasons. They are, well, we refer to various cases. They're all there. Most of them are in the bundle or referred to. And we simply make this submission that it is not possible, paragraph 29, to interpret section 97 so as to mean, as Mr. Justice Mumby concluded, that section 97(4) must be construed in such a way as to permit the court to lift the prohibition in section 97(2) where convention rights require it. That is simply going too far.
Can I just wonder aloud where this submission leads? Does it lead to the proposition that section 97 is incompatible with the Human Rights Act in a case where you're not seeking any declarations of that kind?
No, because I don't think it does, I'm afraid, because...
well, then the whole exercise was pointless. Because you have to start with a conflict between the natural reading of the statute and the requirement of the court to give effect to the Human Rights Act.
No, with respect, our submission is this. I will reflect on my Lord's point because it's obviously an important one to raise. We simply say that there is no room in Section 3 to I'll deal with the reasoning process of Mr. Justice Mumby in a minute. That's a different issue. There's simply no room to do it. So it's one of those instances where there's no incompatibility at all because the terms of 97(4) expressly exclude the possibility of a convention-compatible interpretation. That can happen. It's not impossible by any means. There are statutes which are in mandatory terms, which you can't give effect to. There are also, as we would say in this case is, an absolute prohibition, a single defined gateway, and in our submission, there's just no way in a statutory scheme such as that you can read in or make more...
Well, I understand that, but suppose it said, under no circumstances would the court take any account at all of rights of freedom of expression.
Sorry.
If it said in terms, under no circumstances whatsoever will the court take any account of rights of freedom of expression in deciding these issues, I think you'd accept that that would be a difficult proposition to reconcile with the convention. And then you'd be into a situation where incompatibility would be an issue, wouldn't you?
Well, no, I'm afraid I don't. I mean, I actually stand by what the structure of the Human Rights Act was designed to achieve, which is the governing principle is parliamentary sovereignty. Parliament can do what it likes. That's what parliamentary sovereignty is. And it is possible, and that's the whole reason I took you back to the bringing rights back home stuff, it's possible for Parliament to set up a legislative scheme which simply doesn't allow for a convention-compliant outcome. That is possible to do. That is their prerogative as Parliament. It is not for the role of courts to rewrite legislation, however strongly the views might be expressed about it. I make that point because it's a very important limiting factor about what the scope of the Human Rights Act is. And it's very well established. It does have that scope. I mean, for example, I set it out paragraph 30 in terms of how you might satisfy, as what the approach might be described as. We submit either the language of 97 as being strained beyond breaking point, or it cuts against the grain of section 97, which is the words of Lord Bingham and
But
Shelby.
those are, Mr. Clayton, sorry to interrupt, but those are reasons which are commonly looked at in the context of an argument that it's not possible to read a piece of legislation compatibly with a human rights requirement. And that leads then, as my Lord has said, to the issue of compatibility.
With respect, I think, can you just give me a moment to see if I can make good my point?
I may help if I just say this. I'm looking at section 4 of the Human Rights Act.
Yes.
And a possible outcome of the argument that you're advancing is that we determine whether a provision of a primary legislation is compatible with a convention right. That's section 4, subsection 1. If we do, and we're satisfied that the provision is incompatible with the convention right, we may make a declaration of that incompatibility. That's the power that the court has. It's not a question of rewriting the legislation. That's the normal consequence if you can't find convention-compliant interpretation. And of course, there's a whole procedural regime which comes with that.
I accept that, but with respect, you don't get there ever. And the reason, can I ask you to look at Re-S, because I wanted to confirm how the House of Lords actually dealt with the point. And the one thing they didn't do is consider a declaration of incompatibility.
Is that Re-S minors?
This is Re-S care order, implementation of care.
What page of the electoral?
I'm looking at page 59 in the core bond, the authority bond, which is the outcome of the appeals. It's the speech of Lord Nichols that I was principally relying on. But the point I've been asked to address is the section 4 point, and with respect, it doesn't apply. Can I just ask you to read, please, through pages 103, sorry, paragraph 103 to 106.
Yes.
The point I'm making, and I've also, I mean, so far as I can see, looking at the orders which appear at 61, there's no discussion in that case about declarations of incompatibility. Likewise, in fact, in another case.
Does one have to look at 102 as well?
Sorry, forgive me, 102?
Where Lord Nichols says the analysis he set out adheres faithfully to the scheme of the Act and conforms to the requirements of Article 8.
Sorry, forgive me, I'm just trying to find you.
102, paragraph 102.
Paragraph 102, sorry. I'm sorry, I'm looking at the wrong.
It's
Still
page,
on page 59.
still on page 59.
Is it? Can you give me the page numbers?
It's 59.
Oh, well, I've lost the page numbers.
It's 326 of the report
59. Sorry.
and page 59 of the electronic one.
Sorry, and you were asking me to look at
The first sentence of paragraph 102.
102. Well, I've read that, but I still make the submission that no declaration of incompatibility was made in Re-S, as far as I'm aware. I mean, I suspect my book, which I don't have, will have the answer, because I know somewhere in it we listed all the cases where declarations of incompatibility were made, which certainly include this one. But as I understand it, we don't get to section 4. But can I deal with it in this way? I think that's right. I'd like the opportunity to reflect further on that, because it isn't something.
Yes, and in any instant case, the court has to consider the particular provision of the of the convention,
Yes.
the article which is in play.
Yes.
And here we're concerned with Article 10
And Article 8.
and Article 8.
Yes, although
But
Article 8.
in the factual context that we're considering,
I understand.
And Article 6.
and Article 6.
Well, but no one's. Well, I suppose potentially Article 6. Potentially Article 6. I mean, I'm not saying that doesn't feature on the facts, but I accept that it could do.
So you're going to come back to this point.
Before you go back to your speaking name, while you've been interrupted,
Right.
may I move away for a moment from
Yeah.
interrelation of the Human Rights Act and Webster? If you're allowed to argue this point, I'd like us just to look at the practicalities of what you're arguing. Now, if at the beginning of a child arrangements application, the case starts, then Section 97 obviously bites,
Yes.
and that applies throughout the hearing.
Yes.
So in these proceedings, all in the early stages, during the fact find, and so on and so forth, the press, the world at large, were all bound by Section 97.
Yes.
Yeah. Now, I think we are agreed, or I presume we're agreed, that Section 97 comes to an end at the conclusion of the proceedings.
Yes.
So at the conclusion of the child arrangements proceedings,
Yes.
then the powers that are outlined in Section 97, regardless of how Webster and various other cases, which I don't think you've referred to, but that deal with the Webster point,
Yeah.
whatever they say, Section 97 has no further role.
I do accept that.
Right. So after that, once a case comes to an end,
Yeah.
in order to have anonymity going forward,
Yes.
an application has to be made under the inherent jurisdiction for an injunction.
Yes.
And so your lay client, if he was seeking to protect the privacy or the identity of the child that
Yes.
they're concerned with, would make an application for an injunction under the inherent jurisdiction.
Yes.
And under that power, we would be looking at pure section Article 10 and Article 8.
Yes, you would.
Right. So I'm just wondering where on earth you think that Section 97 is taking us, because these proceedings are nearly concluded. I understand that you're awaiting a judgment from Mrs Justice Arbuthnot on an appeal from the order that was actually made, and at that point, because unless there's a second appeal, which would be very surprising, that is the end of the proceedings.
Well, with respect, there's rather. I mean, I'm obviously not.
So just
Yes, sir.
let me follow through where I think we've got to, and then
Oh,
let you
certainly.
know how you think. So at that stage, that's the end of the proceedings, and at that stage, then you, on behalf of the father, could make an application for an injunction.
Yeah.
At which stage the court would be concerned only with Articles 10 and
Yeah.
Article 8, and Section 97 has nothing to do with anything. And so I'm just wondering why you're even asking us sense to go into this argument that wasn't dealt with at the first stage, which has not been fully explored in any of the skeleton arguments, when the reality is these proceedings are nearly finished in any event, and we're very soon moving on, inevitably, only to an Article 10 and Article 8
Well,
argument.
I'll make two separate points.
Certainly. Because
I
I do
certainly-
need some help about
Yes,
that.
well, two separate points. Firstly, I will move on to the Article 8 and Article 10 debate shortly.
I'm not asking the merits, I'm just
No,
saying, why are
it
we
is
even looking at section
because of
97?
this. The actual subject, the subject matter of the appeal was effectively, as I understand it, a case management decision made on the 4th of June of 2021. It did appear certainly long before the skeleton, sorry, long after the skeleton was submitted. Did that application, was that application made known?
Changes to that, a case management order of the...
Just to the one of, can I go look at the, sorry, it's referred to in our skeleton argument. If I can just find it for the Court of Appeal. You give me a minute. It's page 53, sorry, is where it starts, and in there we set out.
Is that 53 of the core bundle?
Of the core bundle, yes. And if you turn to page 55, in fact, actually it's probably 56. Yeah. If you turn to page 56, the hearing to which I was referring was on the 4th of June of 2021, where various orders were made by Her Honour Judge Willis. You see that?
Where to find the order?
We don't have the order before you, but then no one's ever queried that this is not an accurate reference.
Well, could somebody provide us with a copy?
Yeah, certainly we'll do that. We'll certainly provide. I'm sorry we don't have it with you, but there is a second point which I ought to make, which is that the appeal to which my lady refers to was actually only served on father very recently indeed, or shortly before, certainly after the skeleton argument for the Court of Appeal was granted and after permission was granted as well.
But I'm still not sure what the relevance of section 97.
Well, there's
the
no
stage
reason
we are in the proceedings. Why are we even looking at it? Because within the second, Mrs Justice Arbuthnot hands down her judgment, which presumably is imminent, given that it concerns a child and continuing contact. Section 97 has nothing to do with this.
Well, why assume that that's appeal is bound to succeed?
But it's still the end of the proceedings. It doesn't matter whether the appeal succeeds or not. I mean, I'd be correct if the parties anticipate continuing proceedings after that.
May I rise, my lady? In fact, the decision that was made on the 4th of June, which is subject to appeal, that's a decision made by Her Honour Judge Williscroft, was an interim case management decision. There is due to be another hearing on the 18th of November before Her Honour Judge Williscroft, when the case will continue.
Notwithstanding, there was an appeal hearing in front of...
Yes, but that was an interim case management decision in respect of an interim decision about contact and secondly about contact costs. There is due to be a report which will hopefully be filed and served by a psychologist, potentially by December, possibly January, but the identity of the psychologist has not yet been agreed by all the parties. A final hearing has yet to be listed.
Thank you very much, Ms. Brown. Thank you.
I'm grateful to my friend Dr. Prout. Obviously, my slight difficulty is I'm not involved in every element of this case, which I apologize. But as I've understood the position, and it's now been explained rather better than I could, that the case is not about to end, and what's more, at the time that permission was granted and the order by Lord Justice Baker made, we were completely unaware of this appeal anyways. So it's not, I perfectly understand the concern about the court, about a purely academic point, but in our submission this isn't a purely academic point, because it's clear that there's still some way to go before this case is finally resolved.
Right, so you've made your submissions in relation to section 97, or are you coming to the end of your submissions in relation to section 97?
Well, what I propose to do, if I may,
Yes.
is I've made the point about rewriting, and what I want to do is just take you quickly through why we submit that the decision of Mr. Justice Mumby is not correct. And what he holds, paragraph 31.
Well, should we get the case up? Where do we find it in the bundle?
Well, what I've done is I've cut and pasted every relevant passage from it into the thinking note.
Well, I'd like to look at the
Oh, sorry.
authority.
It's AB 331.
Thank
You can find authorities bundle 331.
Very much.
And the passages which are most central to this point are really begin at paragraph 51, which is at page 331,
Thank you.
and carry on through to, I think, 62. So perhaps you could read those, please.
Yes. Yes.
Thank you. Well, what I've done, thank you very much, is at paragraph 33, I've set out the reasons why we question that judgment. First, Mr. Justice Mumby identifies the ratio in Clayton and Clayton, which my Lady Justice King was referring to before, but holds that the observation of Lord Justice Wall were not obiter. That's at paragraph 59. That, with respect, is difficult to sustain because the issue of Article 10 was raised for the first time by Lord Justice Wall at paragraph 93 of Clayton and Clayton, but it wasn't considered by Sir Mark Potter, then President, or by Lady Justice Arden, as she then was, who agreed with the President's judgment. So in other words, Mr. Justice Mumby proceeded solely by reference to the remarks of Lord Justice Wall. That's the first point to make. And they were just made by Lord Justice Wall, and they plainly must be obiter. The next point we make is that nowhere in Mr. Justice Mumby did he grapple with the Section 3 interpretation, the question of whether it's possible or not, because no submission to that effect was made before him. And therefore, we would respectfully submit that this is a case where the point simply wasn't taken. It happens. The third point we make is that he purports to hold, this is the third, paragraph 3, it's clear the court has the power both to relax and increase its restrictions. The answer is provided by the speech of Lord Steyne in the identification publication case. With respect, that answer is only correct if no consideration is given to this question: is a Section 3 interpretation possible? If it's not possible because of the language of the statutory provision in question, that's what it means when it says it's not possible. And in those circumstances, we would respectfully submit that the decision by Mr. Justice Mumby is per incuriam, and we would therefore invite the Court of Appeal to decline to follow it. Per incuriam because it's based on saying something was part of the ratio of Clayton, which wasn't, and it operates or proceeds on the basis where there's no argument about the possibility of reconciling Section 97 with convention rights, and therefore it can't be definitive in terms of its implications.
We do see from paragraph 12 of Webster that the children's guardian was opposing any relaxation of the order that was issued.
Yes.
I remember quite well the guardian was
Well, you were in.
pretty strongly opposed to any
Well, my lord
opening up of.
My law has the advantage over me because but what I would say
I'm not taking advantage of that. I'm just taking advantage of what's in paragraph 12 of the judgment.
I understand that, but I mean I have gone through Clayton quite carefully, and there's no submission to the effect of the one which we advanced before this court. I can't see it.
No, we're at cross purposes. I'm addressing the submission that you've just made. I think that the proposed interpretation, that the issue of whether the Section 97 could be interpreted in the fashion that he did was not disputed before him. There was no one arguing the other side of it.
No. So I'm making a much narrower point than that. My narrower point is not that it wasn't disputed, but the argument of law, was it possible to interpret Section 3 so as to do that? That point was not taken.
Yeah, well, we can't tell.
Well, it's not. It doesn't appear in the judgment at any rate. And in our respectful submission, unless the argument is actually being put, the argument, one must assume that the judgment proceeds on the basis the point wasn't argued. That's the submission, anyway. Just to wrap up.
Wouldn't follow that the decision was per incuriam on that ground alone.
Pardon me?
It wouldn't follow that the decision was per incuriam on that ground alone. Maybe the parties might not take a point because it's simply a bad one.
Well, of course. If it's a bad point, doesn't matter. No. But in our submission, and it's a matter for my lady whether you think it's a bad point or not. I'm not suggesting, my case proceeds on the basis that the points I'm making have some substance in them. If your lordships are against me on that, so be it. I'm not saying that it's per incuriam if I'm wrong. I'm saying it's pure incuriam if I'm right. That's the point I'm making. And just so that we're clear, the language, as I conclude this part of the submissions, with this point really, the fundamental point that we make and how you express it in terms of constitutional boundaries or whatever, doesn't matter, is it's one thing for the court to interpret statutory words, that's one thing, but it's quite another for the court to rewrite a provision. And you are, in our submission, rewriting the provision if you're taking an absolute prohibition, one exception out, which dispenses with that prohibition, and yet you want to add something more into it. It's just that the mandatory language of Section 97 simply doesn't permit that. It's one of those unusual instances where it's simply not possible to interpret Section 97 in the way Mr. Justice Mumby does. That's the point. If it's right, it's right. If it's wrong, it's wrong. I leave it with you.
Just so that I'm clear, you've referred in your thinking and speaking note, or is it in your skeleton argument, to read J, which of course was another Mr Justice Mumby, so not surprisingly he agreed with himself.
Yeah.
But I have a recollection, and it may be that Eugenia needs to check this for me, that there was a case, was it called Medway, which Sir Mark Potter dealt with this and confirmed his view that Mr Justice Mumby was correct.
Well, sorry,
I can't remember the detail of his analysis.
No, okay.
But perhaps someone could check. But
But-
I have it
but-
in my mind.
Well, can
Eugenia's nodding. Thank you.
Yeah, can I, yes. Well, can we look at, I'm just conscious that I don't have a lot of time, so maybe some of these points perhaps I could deal with in after the short adjournment.
It's just as you're featuring on the fact that you're saying this wasn't properly argued.
No, I understand.
Put that it may be that if Sir Mark Potter, when he was president, endorsed that approach, he may have told us why.
Yes, I entirely accept that. Can I move on to a different point now? And these are a whole set of submissions which apply, assuming that we're only dealing with the Article 8.10 balancing exercise. So all these submissions apply irrespective of, well, if my lords and ladies is against ladies and lords is against us on Webster point or not. Taking it from the speaking note, we say if there has been a failure to attach proper weight to a convention article, then the court is required to re-exercise its discretion. That logic applies equally if there's a problem over Article 8. And we will be submitting shortly that there's a fundamental problem about Article 8, which I'll come to in a minute. The next point I want to make is this, paragraph 41 onwards, we of course accept, and I want to make this clear, we entirely accept the criticisms made against Paul. There are serious ones. I don't want anyone to imagine we're seeking to make light of that. But in our submission, it's quite important, as the journalist expressly recognizes, paragraph 41, that the conduct complained of and which is said to be published is not behavior to the child. It relates to the father's conduct prior largely to the child's birth. And the one exception to that is the footnote about shouting at the child at the early part of the life. And sorry, 42 makes a point about it, entirely accepting it. But it's important to remember that this isn't a case, at least on the face of it, where there's a suggestion of abuse in relation to the child. One point which we would make is there's not a very obvious and straightforward connection between the fact findings, serious as they are, paragraph 43, and the father's application or the child's welfare. And we next make the point that, as Lord Hodge said in the FZ case, a child must not be blamed for matters for which he or she is responsible, such as the conduct of a parent. And we do invite the court to give careful consideration to that point. I'm not saying that the father's conduct in any way is defensible. I'm not saying that. But our case places at its forefront the child. The next point I want to make, can I just ask you to read paragraph 45 of the speaking note? And the concern we express at paragraph 46 are there any limits if one simply applying an Article 8.10 balancing exercise? Are there any limits to identifying the parties in private law family proceedings? Can I ask you to read 46 subparagraph 1 and actually 2 as well, please? Or 3, is the rationale for identifying parties confined to public figures? If so, why? Why them?
Well, the issue always is a very intensely fact-sensitive one, isn't it?
Well, the difficulty with that is really the point we made.
Well, is that not something
well,
that's correct?
In ours, let me just put the point in this way. There are obvious practical implications for the family court if the effect of, if it's completely an open textured question, it's a fact-specific inquiry in every case, that in any case where there's a suggestion, where there's an adverse finding, will there be an application for identifying the parties in that case? Now, that's simply a practical point that we raise. It does rather suggest that possibility. Now, that may not trouble my lords and my ladies.
But this is a very specific kind of point that's being made in paragraph 48 of the judgment of Mrs Justice Lieven. It's not just, well, this is the kind of conduct this person engaged.
No, okay, I accept that.
So I see that you might say, well, it's the usual question, pointing out that someone has feet of clay. Query why that's a beneficial thing. That's one debate, but
there's a spectrum, and I accept the force of my lord's point. It may be that the answer is that this case is so fact-specific to this individual that speaks for itself. Maybe that's the answer. But I pose these questions not to be awkward, but just to suggest that there are some issues that one needs to think through about this. And we also question, but this may not be of significance perhaps, that what the rationale is for identifying the parties. And particularly, is it based on the notion of punishment or deterrence? This is paragraph 47 and 48. It's a very odd idea in the non-criminal context to rationalize or justify the application of a principle by virtue to those concerns.
But surely the identification of parties to legal proceedings doesn't need to be specifically justified. It's the norm.
Well, we would respectfully submit in this context, it isn't, well, like so many things, it all depends how you look at it. It does require some justification in the private law family context.
Yes, I mean, you've got to look at it as you well know from both sides.
Yeah.
The parallel analysis.
Yeah.
One's got to ask, well, which bit of that analysis is one undertaking?
Yeah.
So on the one hand, you've got to question what's the justification for interfering with freedom of expression, the freedom of communication of this information, and on the other hand, what's the justification for interfering with the private life interests, rights that are at stake?
I accept that, and I accept also that one approach would be to say, well, what the approach the judge took was that it's a very, very fact-specific rationale for the identification. So I'm going to next deal with a very short point about the finding of rape. And I want to make it absolutely clear that in the light of the submissions advanced by everyone, we've given very careful consideration to the point. And what it comes to is this. Really, that there are, the question of what to disclose in the published judgment involves the exercise of discretion. And we would respectfully submit that that discretion, it would involve the learned judge taking a second look, or giving this is paragraph 55, specific consideration to the potential impact of the publication on the child's welfare. There is an editorial function that the court has, which is important for the courts to acknowledge, which is that the potentially devastating impact of reading on the internet, that would be a factor which would entitle the court to say, well, that is not something to include in the published judgment. That's the front. the force of the point, good or bad. Can I move on to a rather more fundamental problem in our submission about the Article 8 approach that's been taken here, both by the parties and by the judge? And this is something which won't take you too long, but it's really this, paragraph 59. Article 8 requires a claimant to show he has a reasonable expectation of privacy. It is trite law that in ascertaining a breach of a person's reasonable expectation, the court must assess the effect of the interference on a reasonable person. It is therefore fundamentally incorrect, and this is the vice which we advance, for the court to proceed by conducting an Article 8 analysis purely from the subjective viewpoint of the individual whose article rights have been subject to interference, like a child. What's happened here, which in our submission cannot stand, is that the brunt of the submissions made, other than by ourselves, before the learned judge, was you have to look at the position of the child. That is not what the reasonable expectation of privacy requires. It requires the court to put itself in the position of the child and to assess whether there is a breach of that reasonable expectation of privacy. In other words, it is simply no answer at any privacy case to say, well, the child's so young they don't have Article 8 rights. I mean, there are two Court of Appeal authorities and Lord Toulson saying that's not right. And there is a shortcut which has been taken in this case, which in our submission is a really fundamental in character. Because this Article 8 case never gets off the ground. And the reason it never gets off the ground is the judge never addressed the question of reasonable expectation of privacy because she was never asked to. We said no, the other side said yes, she acceded to the other side's submission.
But are you saying that she held that the Article 8 rights weren't even engaged?
Well,
because that's what that test is all about. And usually it's applied to information about the person concerned rather than information about their parents.
Well, as I understand it, and the way in which the judge dealt with it was to say a 3-year-old effectively doesn't exercise Article 8 rights because she's too young to have them or to be conscious of them.
Could we look at the relevant passages of the judgment?
Yes. Well, let's do that. I mean, if you give me 1 minute, it's 56 and 57, which I think is going to be in the core bundle tab 2.
The electronic page number?
38.
Thank you.
Can I ask you to read 56 and 57 first of all? Now, it's important not to trip oneself up about terminology, but in our submission, the language of 56 and the comparison the judge makes between a child of 3 and a child of 10 years older is effectively saying that this child of 3 doesn't have really anything of substance to throw in the balance. And that, with respect, can't be right. That just can't be right. And it's contrary, as I say, to 2 Court of Appeal authorities and a statement made in the Supreme Court. That's the thrust of this submission. And if I can just take it slightly more quickly. But we say paragraph 67 that the distinction the judge made between a child of 3 and a somewhat older child is contrary to basic principle. Because on the learned judge's view, it would seem in our submission, submission that no 3-year-old is capable of successfully invoking Article 8 in the instant context. Now, was much debate some time ago about what the word engaged means in the context of convention rights. But in our submission, what effectively the judge is deciding in paragraph 56 is that X's Article 8 rights are not engaged. How we read it? That's the
Not
submission.
engaged,
Well,
as opposed to minimal.
well, that's why, in fact,
that's a critical difference.
well, and that's why I'm hesitant about terminology. What I would simply say is this, is that to say it is trivial involves looking at it purely through the age of the child.
Well, that's a different question, but the judge, my reading of the judgment is that the judge was starting on the premise that the child's Article 8 rights were engaged, and then did the res balancing exercise by reference to specific facts of the case.
Well, sorry.
And if one goes on, look at what says in paragraph 59. Therefore, having carried out the intensive and fact-specific investigation of the different ECHR articles in play, etc.
Well, as I say, I don't want to get bogged down in terminology. But what the point I want to make is this, is that the weight or the significance to which the judge addressed the child's Article 8 right was saying there was...
That's a different point.
Well, if it's a different point, I apologise. It may be the way I'm expressing myself badly. But the point I want to make is, in our submission, of some importance, which it is just wrong in principle to say, well, the child's 3, so they're not going to know much about it. But if the child was 13, it would be different. When material remains on the internet forever, we know that. That's important. It's no good to say, well, she won't notice it at the moment.
Well, that's the point that the judge addressed in paragraph 57, isn't it?
Forgive me.
She's addressing the media interest, and the things said on the internet do remain in perpetuity. You can criticise her assessment of that, but I don't think you can say she didn't pay attention to it.
Well, let's analyse 57 for a moment. The likelihood of the media is it will pass quickly. Well, with respect, that's irrelevant in terms of the internet. Material remains there, so that's simply irrelevant. Secondly, the explanation will be given at age-appropriate age of the sexting sandals and the contact with his father. By whom?
So I was just worried that you might be straying beyond the boundaries of what we...
I'm sorry.
In your references to...
Oh, I'm so sorry. Sorry. You're quite right. I apologise.
Third line from the bottom.
Yeah, that's sorry. That was inadvertent. I hope you accept.
Yes.
We take it that for this purpose, what you said about that just now, and indeed what is contained in that part of the judgment, will not be reported until further order of the court.
Thank you very much. Can I apologise? I am sorry.
I was just in your own interest, really.
No, thank you. I understand that. Thank you very much. But
you said explanations are going to be given to X in any event at an age-appropriate time. And you said by whom? Well, I mean, this is a tiny child, and as I understand it, there's no appeal against the order that this tiny child is going to live with its mother going forward. So I don't think it's an irrational conclusion to say that the child's mother will be providing those explanations appropriately.
I understand that. But again, we would respect.
Who else would?
Well,
why should it be anyone else? I should.
That's yeah. I accept the force of that. The point I really make is this: is that in our submission, at any rate, we're dealing here with unpredictable consequences of material appearing on the internet. My lords and ladies have seen that sort of material already in this case. And the fact is, as the Association for Children, lawyers for children say is that can be potentially damaging. And given that, it is in our submission unrealistic to say that the significance of that publication is addressed by the points made in paragraph 57.
But we've got the judge saying, second line of 56,
Yeah.
that the child's Article 8 rights are of very great importance. All right?
Yes.
So that's the starting point of the judge. Why was the judge not thereafter entitled to analyse the impact, having taken into account that they're of great importance, to analyse the impact by reference to all the factors in this unusual case, including the child's age?
The answer to that point is this, is that the publicity is not frozen in aspect. The material remains on the internet.
The judge took that into account. The judge says so, recognises that.
Well, perhaps she says that the media storm will pass quickly.
It may be there will continue to be some media interest in the years to come.
But that
Things
was,
said on the internet do frequently remain in perpetuity. This judge was not being naive about future publicity.
no, I accept that. I accept that. But in our submission, the focus on the child being a child of 3 rather than 13 is slightly odd. I mean, why, for example, if you look at some of the cases, and they'll be familiar certainly to Lord Justice Warby, but if we look at the Weller case or the Murray case or what was said by the Supreme Court, those were cases, admittedly were about photographs, which really doesn't matter very much, but those were photographs taken of very, very young children, actually less than 1 year old. And their Article 8 prevailed because they were given a weight and significance, which is wholly different.
Yes, but I think you're missing a key point here, which is that the what the court then does is assess that as against, for example, what public interest there might be. Answer very little, if any, in publishing the faces of very young children in an entertainment section of a tabloid newspaper.
Well,
I mean, here the exercise the judge is engaged in, a very important one, is looking at the significant, on any view, Article 10 issues that are in play as against, or when balanced against, the Article 8 interests of the child.
well, with respect, our submission is that if one looks at the Weller case, that is not the approach that Lord Dyson takes in the Weller case.
You better
Let's
take
just-
us to that passage.
Yeah, let's
then.
take that out. You'll find it. It's the particular bits I'm interested to make this point in. It begins at AB 504. It's the consideration of the Murray factors, if I can put it right.
Is that
This is tab 18.
Cover.
which page in the electronic bundle?
504. It should
Thank
be.
you very much.
Which paragraph are you taking us to?
Sorry, can I just find I'm taking you to the approach that Lord, could you begin at paragraph 30, sir, which is at 503. Paragraph 30, and then turning over the page, sorry, my pages are falling out. He then deals specifically with the Murray factors. And could I invite you? This is all before you get to the balancing exercise. I hasten to make that point because the president made a point to me about the balancing exercise. You see, this is all dealt with before the balancing exercise, which appears at paragraph 39. This is just about the position concerning a child. Okay, I could ask you to read that.
Well, I noted paragraph 36, the second sentence.
Well, can I just take you back?
The point is, Mr. Clayton, that the court was addressing the prior question, which relates to the issue my Lord or Justice Warby raised, which is the engagement of Article 8 rights in the first place. In this case, there's no issue about that. Not suggested they're not engaged. We're on to the second stage. At any event, which other passages do you want us to look at?
Well, those were the passages. What I was particularly taking you to, I accept upon the preference it's made to me, and I'll come back to that in a moment. But what I was actually doing, at least in part, was to try and point out that the exercise, all this analysis appears before you come to the other side of the equation, the Article 8 equation. So that was why I was taking you to this passage, because you have to throw it into the balance when you look at the Article 8 case, the issues which arise by virtue of the fact that the child is simply young. And it may be that the court takes the view that the brief consideration of it in the judgment is sufficient. In our respectful submission, the points made by Lord Dyson go rather further than that. And they do require a little bit more detail than simply saying, well, it would be different if the child was 13.
Well, I think one needs to look at that, the whole of that authority before one goes on to look at paragraphs 40 and 41.
Paragraph
40 and 41.
Yes.
39, 41.
Yeah.
There you've got the court looking at the second stage.
Yes, but what I'm trying to focus on at the moment is the approach that was taken to, in our submission, the most striking element of the case, which was the treatment in paragraphs, I think it's 55 and 56, of the child's rights, which is extremely summary. And
there is a factor here, and when you get to look at the authorities that we sent through rather early this morning, you'll see that the Supreme Court has held in a case called Rhodes that a child doesn't have any rights to stop their parent disclosing facts about the parent's life. Or Mrs Justice Lieven dismissed the case entirely where the child was trying to stop that happening on the basis that the child would suffer psychiatric harm if that disclosure was made. So that seems to me to be an important distinction between the kind of case we're looking at here,
yes,
where it's information about the child, it's the child's appearance in its pushchair, or
yes,
and information which isn't about the child, as you pointed out in your own submissions. It's about what happened between the parents.
yes. Well, can I obviously ought to read the case, those cases, and I promise I will do that. So I'll finish early, so that I'm not taking up undue amount of time. But I obviously will read it, and if there is a response, a proper response, well, I'll indicate the response and what we have to say about it. But I'm unfamiliar with those two cases. I'm afraid I apologise for that, but I am.
Right.
But as I say, well, the point that I've made to the court is I think set out fairly and squarely. My lord, the courts have the point I'm making, which is in effect the treatment in paragraphs 55 and 56 are very summary, and if that's sufficient, that's a matter for the court. But in our submission, it is not very satisfactory to say it would be different if the child were older. Why should that turn on the age of the child? Which brings me conveniently to the next point I want to make, which is the absence of any mitigation measures. There was a lot said before the learned judge that there were attempts that were going to be to mitigate the effect of gaining information via the internet. And the plain fact is, there are none. If and when this comes up, it will be printed.
Does redaction of the judgment not count as mitigation?
Well,
I mean, that's a genuine question.
No, it depends on the redaction, obviously. I
mean, if I have looked at the first instance judgment, and the very, very significant passages, which would undoubtedly cause, if I put it like this, extreme embarrassment to your lay client, have been removed.
No, I understand that.
So is that or is that not mitigation?
That's a form of mitigation. My point, the answer is yes. My point was directed to the suggestion that which was made by behalf of Ms. Tickle, was that there were a number of other mitigation measures which just don't work as mitigation measures. I mean, they're issues of fact, and you can see them from how it's put, but they aren't mitigation measures. I do accept redaction, maybe, but then, and I made my submission about the rate point. You might take the view that in some circumstances, at least that would be an inappropriate thing for a court to put in.
Well, you'll come back to those questions once you've reflected on the what is said in roads in particular, Cuja too.
Yes. Can I just have a moment before I close? I think because I'm still within my allotted time. I think. Right. Okay. I think we'll just have to. It's clear there are important points of distinction about the case which I've yet to read, which I understand involves a criminal liability. So I need to look at that. Obviously, I've got to read it, and I haven't. And I can tell, say, that my learned junior has found the case that Lady Justice King asked about, the Medway case, and we can forward it to the court if that helps. And perhaps I could, over the short adjournment, can comment on that too. So I think, subject to that, unless there are any other specific questions, I have said what I can say.
No, thank you.
Questions?
Thank you.
Very much. Yes, who's next? Ms. Reed, yes.
As the court is where I'm here on behalf of Mr. I'd like to make 4 submissions under 4 main headings. Before I do that, I'd like to set a little context. But for the court's benefit, the 4 headings I want to address are relating to the nature of the evaluation exercise that the judge was carrying out, incorporating the submissions I want to make about why it would be wrong to allow that issue to be reopened when the nature of the exercise and the process was conceded below. I say that noting that there is only a limited extent, I think, to which Mr. Clayton in oral submissions has challenged the nature of that exercise, but I do still need to address that to an extent. But really that first point will wrap up my response to rounds 3, 4 and 5 of the appeal. I'll then address the question of section 97, including why I say the court should not be dealing with that issue at all, it not having been run below and in fact having been explicitly conceded. That will deal really with rounds 1 and 2 of the appeal. If permitted, I will briefly address the court on the ancillary matters that are raised at paragraph 92 of my skeleton about what could be done with some of the documents appeal. I've put to one side for the moment the question raised in the supplementary skeleton, which I know is in a slightly different category, but I will, if I may, briefly address the court on that. And then, if there was time and if it seems appropriate, I might make, on behalf of Ms Tickle, some brief submissions about broader issues of protection guidance. But just to look, first of all, at the context. The context in respect of this applicant, Ms Tickle, and the application that was made to the court below. I know that this court will be familiar with seeing all sorts of different litigants, parents, media organisations as part of the proceedings, probably less familiar with seeing independent journalists appearing as parties pursuing these applications for a range of reasons. And Ms Tickle, as the court will have picked up from the papers, is an independent journalist whose area of specialism is in reporting matters relating to the family court, both individual cases and the systemic issues that may or may not arise in relation to the work of the family court and in relation to the challenges of reporting the work of the family court. Ms Tickle began trying to report this case almost a year ago. The fact that this appeal is still underway after such a long time, of course, in itself to an extent represents an interference with her Article 10 rights. She has invested substantial time and effort, has gone to personal cost and risk.
When you say Article 10 rights, you mean in the by reference to her position as a journalist?
Yes.
And the dissemination of information?
Yes. I simply mean, it's not a criticism, that the fact of how long the process has taken has meant that publication has been and has had to be delayed. And of course, the type of material that Ms Tickle wishes the court to publish and subsequently to be able to report on is to an extent time sensitive. That's not to say that the public interest has gone away, but it is time sensitive. Things can change.
Of course. And now you do you date that from June? Because we were told that there was an interim application.
Ms Tickle first sought a copy of the judgment in, I think it was December 2020. She received
You're talking about the judgment
of the
appealed against.
no, of the fact-finding judgment.
About what I mean, the judgment that was dealt with by Mrs Justice Lieven.
Yes. So that application for permission to publish the contents of the fact-finding judgment and or for the court to publish its own fact-finding judgment was initiated when Ms Tickle in December 2020 sought a copy of the judgment. In February she made her application. For various reasons which I don't need to explore, it finally came on before Mrs Justice Lieven in July. The decision was made that the application should be allowed. The reasons the court is familiar with, we're here today, almost a year after that process started, hoping for a decision as soon as the court is able to give one. As an independent journalist, that's quite a big deal, quite a risk, an investment. An independent journalist doesn't get paid until the story runs. She is here, she has secured some funding, that in itself speaks to the public interest in this case. And what I want to say about the context is this. Ms Tickle has fully engaged with the really important arguments and concerns raised about the privacy and welfare issues relating to the child. And you can see, the court can see that in the colour-coded copy of the judgment that Ms Tickle produced as long ago as March. That was her attempt to carry out what I would say is a journalist's 3S exercise of trying to work out what she really needed to publish, what really shouldn't be published, and the things that perhaps were less important for her that she didn't have a strong view on.
Could you give me a page reference for that?
Yes, of course. That colour-coded judgment appears at tab 11 in the core bundle, starts at page 170.
Thank you very much.
And I'll get the colour coding wrong now, but by recollection, the yellow were the bits that Ms Tickle thought were really important and had particular public interest in. The green bits were the bits, perhaps counterintuitively, that she thought should be redacted, and indeed were all redacted. And the white bits, the bits that weren't colour-coded, were the ones that she was less particularly concerned to be able to report, had no strong view on. So that was March last year. And Ms Tickle has worked really hard to think properly about the issues that this unusual case raises. I think it's right that I say on her behalf that in the course of pursuing her application, submissions on the part of the father in writing and orally variously suggested that she is naive, misleading, reckless, or oblivious as to the child's welfare. It's been implied that she had overstated the public interest in order to get what is really a story with a much more base commercial interest. And it has been asserted, although I don't think it's maintained for now, perhaps it is, that the motivation for the application was some sort of name and shame exercise. That's set out in the skeleton argument for Mr Clayton on appeal, paragraph 2. He's briefly referred to it today, obliquely. And at paragraph 57 of Mr Clayton's skeleton argument, he says that Mrs Justice Lieven had referred to the journalist's desire to expose, in inverted commas, the father. That is Mr Clayton's paraphrase, paragraph 24 of Mrs Justice Lieven's judgment. It is a misstatement of the position of Miss Tickle and indeed of Mr Farmer. Because what paragraph 24 is about is the wish on the part of the journalists and indeed on the part of the mother to expose the broader issues that this case raises. The media are, of course, commercial organisations. Miss Tickle would very much like to get paid, but she has got a quite proper desire to report on issues of public importance, and she has approached the matter responsibly. And I want to say this, at first blush, a family lawyer might say, in fact, I said when I was first asked to assist with this case, that this was an audacious application to make, not because it involved publication of a judgment, which is or should be relatively commonplace, but because the application was to publish in conjunction with the names of the adult parties. Never, I should say, is there any request made to publish the name or image of the child. But in fact, it's not audacious, very unusual, but it's fundamentally an application rooted in the unusually high public interest in a person with the characteristics, that paragraph 16a that I referred very much. Those characteristics which I'm not going to refer to in open court, but which were at paragraph 16a, my earlier skeleton argument, which I addressed the court on the preliminary issue. It's fundamentally rooted in the high public interest associated with those matters, and with the father having been shown to be seriously domestically abusive and raped his wife. From the point of view of a journalist, and I suggest the public, it's obviously something the public would feel they should be told about. This was never some sort of kiss and tell story. In fact, it's not a kiss and tell story at all. What Miss Tickle wishes to say to the court is that the story she wishes to write, which will be unlocked by publication of the judgment and facilitated by her being able to use some of those other documents in the ways that I've set out in paragraph 92, is about sustained abuse by a powerful man, and the court knows in which ways he specifically was powerful, who used his very position to threaten and coerce women, plural, and used the media to give a false impression to garner public sympathy. And it's about how the family court dealt with the victim of that abusive behaviour. In his first skeleton argument, Mr Clayton, or in fact not Mr Clayton, but father's counsel at the time, said if this were a fact find between any other parents not the public eye, the request would not have been made. That reference is at paragraph 30, page 200 of the full bundle. That's quite so, I adopt that paragraph. Because this application was always advanced on the basis that publication would be in line with the victim's consent. Ms Tickle proactively suggested redaction of the most intimate details and extraneous information relating to third parties. It was always advanced on the basis the child should not be named. There should be a prohibition on that. There should be a prohibition on images of the child. And I pause to say that the authorities very clearly demonstrate that photographs, images of a child are in a wholly different category. And that any identification would be indirect only through the identification of parents.
Just on images,
Yes.
just as a matter of fact, I understand that some considerable time ago, not connected with this case specifically, images of this child did appear. Were they taken down?
No.
Or are they still in the public domain?
My lady, they are still in the public domain, kind of paywall, but still in the public domain, and they appear in your supplemental bundle.
I've seen the actual images.
Yes, I haven't checked recently, but certainly they were printed for the purposes of the July hearing, so I don't think there's any reason to think they'd come down. But those particular images are of a very small.
Understood.
And the application was always pursued on the basis that these were highly exceptional facts, which meant that the judgment, if it were published, would be robbed of meaning and key elements of public interest if the identifying information concerning either parent were removed. In particular, mother's role and the information, I'm going to call it the paragraph 16 information, if that assists the court, and the paragraph 16 information. And the particular identity of the father, given the existing material in the public domain, so those articles in the supplemental bundle, which relates to other conduct outside these proceedings. Other conduct of a similar but not identical nature. It is in this case impossible to identify the role of the mother in conjunction with the paragraph 16 information without identifying the parents. There was never any suggestion, in fact it was expressly conceded, that the mother or the child were particularly vulnerable, difficult circumstances, but they were not in themselves inherently fragile. And the father's own rights or any vulnerability was never relied on. And I should say also, neither was any Article 6 point taken. So there was no suggestion that publication would have any impact on the smooth running or fairness of the ongoing substantive proceedings. And as the court has already noted, almost all of the information in the judgment related to the parents, their conduct towards one another, and with one small exception that the court will be aware of from the schedule of findings, did not relate to the child. The only reason that the material was captured, as it were, and needed permission to be published was because it had been aired in the context of family proceedings. There were three main strands of public interest identified, and I'm going to have to cross-refer to some documents here in order to stay within the boundaries of the reporting restrictions. But those are dealt with at paragraph 8 of my skeleton for this appeal, which is page 86 of the court's core bundle. And for the benefit of the court, and I don't propose to go to them now, but just for the benefit of your notes, there are more extensive, more granular lists set out in the July skeleton argument at paragraph 40 onwards, which is page 243 in the full bundle. And paragraph 42 of that argument set out a long bullet pointed list of all the broader and case-specific specific public interest aspects, and paragraph 49 set out some of the much more specific elements of public interest that derive from the parents' identities and role and the paragraph 16 information. But to just deal with it in overview, there were really three main areas. So, public interest in the administration of justice, specifically the family justice system, its treatment of victims and response to issues of domestic abuse and sexual violence. That factor, of course, this case shares with many others, but it is atypical in that this is a situation where findings have been made and there is no appeal, and the information does not come into the public domain as a result of an error or an alleged error. So this is not a re-HN type case, where what the public is seeing is cases that have not gone the way that they ought to have gone. And even that broader element of public interest can only partially be met by publication with what the father would say are the identifying details, paragraph 16 information, the details of what's in those news articles, the subject matter of that other conduct. If that is stripped from the judgment, previous conduct, paragraph 16 information, the judgment would be stripped of much of its texture, and the reader would be robbed of the ability to understand fully the analysis, which talks about power and threats. But it does go beyond that, because it's not just general public interest relating to the fact that this is a fact-finding judgment in matters relating to serious domestic abuse. I do need to refer the court to page 86 because I can't verbalise the second head of public interest, which is at page 86, paragraph 8A. I'm sorry to confuse the court by taking these points in different order than they appear in the skeleton. And that runs with the third element of public interest, which is correction of the record relating to the specific individual, i.e. the father, in the context of the paragraph 16 information, and the subject matter of those articles. So I want to make clear that Ms Tickle makes, and never has made, any argument that there should be generalised or regular naming of parents of children when judgments making findings of domestic abuse are published. She understands that applications of this sort will be exceptional. Certainly that they'd be only exceptionally allowed. The thrust, Ms Tickle doesn't support the publication of judgments concerning proven sexually abusive behaviour absent the consent of the victim of that proven abuse, and in many cases that won't be forthcoming. In this case it was, and the application was always contingent upon that.
So that's a necessary part of her position?
Yes.
The consent of the...
Certainly the first skeleton argument that I drafted in June indicated that at that point the mother's position wasn't known and we had to take an either-or position, and indicated that we would have to respond to the mother's position once it was known. And actually very shortly after, I think the skeleton arguments crossed, the mother's position became known. She indicated her broad agreement with the colour-coded judgment. There were one or two additional points that were redacted by agreement. And the guardian's position, having heard what the mother wanted to say, then shifted also. So I do take issue with the suggestion in the skeleton arguments that this case and Mrs Justice Lieven's decision represents a radical departure from established principle. It really doesn't. It's a classic example of the court carrying out a quite proper parallel analysis that set out paragraph 17(3)(s), the judgment before scheme. And so this application always turned on its facts and and this appeal turns on whether or not the judge properly evaluated those facts. So I'm moving on to the substantive first point about that evaluative exercise. As I think I can summarise, the test that everybody agreed at first instance should be applied, or the process that should be applied, was the RES test, four-stage parallel analysis. In written submissions below, Mr. Clayton had complained on behalf of the father that it was a fundamental misconception to suggest that RES was to be applied on a straightforward basis. And as Mr. Clayton has referred to obliquely in his submissions today, it was a lively hearing. The submissions went around the houses on this issue of whether RES applied, whether welfare was paramount, how the court should be approaching exercise, bearing in mind the competing rights that were in play. And I should say, Article 8 was expressly conceded to be engaged. There was no issue about that. But ultimately, as the judgment records, both at paragraph 40 and paragraph 46, it was conceded on behalf of the father that RES was the test, subject only to what is said on ZH Congo about welfare being a primary consideration. That was plainly right. That was the basis on which the judge ultimately was invited to make a decision. So it is surprising to an extent to see those arguments revived. And although it's not been canvassed in oral argument, I think I probably need to make clear that part of the argument that's run below, and which does appear in the skeleton argument, is that those European Court of Human Rights cases about termination of the family relationship that appear in the main authorities bundle, which typically relate to adoption type cases of permanent termination of the relationship, was said to apply, in effect, that welfare was somehow paramount, even though RES was the exercise. And submissions were made below, and again they appear in the skeleton argument, about the exceptionally high test for a court making decisions of that sort in contact applications or in care applications, and by extension in this application, that the court could not sanction an order unless the parent was particularly unfit. That argument, and it hasn't been pursued orally today, but I say very clearly, was misconceived. This application is not a substantive welfare decision in the sense that the court's being asked to make Section 8 or other orders about the upbringing of the child. It was an application for publication with potential, and arguably potentially serious, but indirect impact on a child. And they're fundamentally two different types of exercises, and the authorities are very clear that in the latter, welfare is a primary consideration, not a paramount consideration.
In the Al Maktoum case, we very clearly set aside the argument at that stage that it should be paramount.
And the other key point to make about that evaluative exercise is that the authorities are also very clear. Two things. Firstly, the court has to apply its common sense. Better to have evidence where there is some, but there isn't always, and it isn't always capable of being directly evident. And there was an exchange, of course, in the hearing below between the judge and Mr. Clayton about whether the judge should be applying her common sense. Yes, it was said she should. And that is, I anticipate, taken from authorities like Weller, which specifically refer to the nature of the evaluative exercise and talk about the judge needing to apply his or her common sense. I don't think I need to take the court to it, but if the court wished to look it up, paragraph 41 of Weller at page 506 of the authorities Weller deals with that. And a number of authorities, Weller at paragraph 56, and the Maktoum case, paragraph 67, talk about the evaluative exercise as being one with which an appeal court will be slow to interfere. I say that the judge conducted that evaluative exercise from a starting point where everybody agreed Article 8 rights of the child were engaged and were of a primary consideration and importance. She concluded that the public interest arguments were really strong. She concluded that the welfare stroke Article 8 child arguments were less strong, were less worrisome than contended for, by some significant margin, I should say. Because the language on the part of the father's team as regards the potential impact on G was that it would be devastating, catastrophic, and of course the father prayed in aid those authorities about a permanent termination of the relationship, which this judge decided was simply not the scenario. And she was quite entitled to do so. It is quite wrong to suggest, I respectfully say, that the judgment effectively says that no 3-year-old can assert Article 8 rights. That's the contention made at paragraph 7 of Mr. Clayton's statement. That's an unfair characterisation of the analysis that was undertaken. There was, as Mr. Clayton has indicated, a lot of questioning in the course of the hearing below, and that was because the judge was at pains to try to understand what all the parties were saying about what might happen further down the line, what might be the worst case scenario, what were the mechanisms of harm that the court needed to be alive to in weighing up that information.
This was all done on an inferential basis without any evidence, really.
There was no specific evidence, and that was partly because nobody sought to adduce any evidence, and partly because, and one of the orders, I think the order from the 10th of June records it, there were specific concessions made, but nobody was asserting that either G, or the mother, or the father had any relevant, I'll call it fragility, but there was no particular characteristic of either of those individuals that weighed heavier in the balance. It was simply the known and established facts. G was a child who was aged 3. The facts are set out in the fact-finding judgment as an ongoing contact application. And although at an early stage the guardian had been really worried about the mother's ability to deal with any fallout from publication, once the mother's position had been made clear that she actually felt she could deal adequately with those issues and had dealt with them before in a different context, those issues were put to one side. And the reason they were raised was because at the June hearing, the first hearing that Mrs Justice Lieven dealt with, I had raised a question about whether anybody was going to be making any assertions about particular psychological or other vulnerability, because if they were, then I'd need to see the evidence that they were relying on an equality of arms basis. And everybody was very clear, it was reported in the news, that no, that was not a part of the case. So that's the background, my lord, to why there was no...
Well, I asked that particularly because of Mr. Clayton's submission, which drew attention to the submissions and evidence that comes from Lawyers for Children, which we were invited to pay some attention to, but that wasn't before the judge.
That wasn't before the judge, and I don't have any particular comment to make on those submissions, other than to say the studies to which ALC refer in their submissions, and which Mr. Clayton now appears to rely on, have been freely available for a number of years, were referred to in submissions, nobody sought to reduce them. And in any event, they talk about children generally, and they talk about children hypothesising. There are no studies, as in fact the Transparency Review, which was published last week, confirmed, which identify specific actual harm to children as a result of publication. What the studies that the ALC referred to deal with is worries that children have about hypothetical situations, by and large. I'm summarising very generally. I don't have the studies in front of me, but they're obviously of general relevance. But the judge was taking into account and heard argument on the general issues around possible impact to children as they get older and through the operation of the internet, etc. On the question of mitigation, in essence, what one can see in the judgment is several key things. First is that the mother's protective care, ability to withstand media attention, the understanding between the guardian and the mother that planned life story work would need to be undertaken with G. And of course, those ancillary matters, redactions, publishers of photographs, etc., would all in themselves act in some way as mitigation or would reduce the potential for adverse impact on G further down the line. As regards the reasonable expectation of privacy point, as I indicated, it was conceded that Article 8 was engaged. I think all I want to say on that is that the cases which deal with reasonable expectation of privacy, and the court's already been taken to some of those, refer back in cases of much younger children who can't offer their own view or who may be oblivious, as G would have been in the short term, refer back to the views of the parents. And of course, in this case, I had competing views of the parents, but the mother's view was very important because she was the primary carer. She was a victim of the abuse in question, had her own informational self-determination rights as put by rights of her own. She's the responsible parent in the court's front of view.
I think we did say in Newman that whilst the caring parent's view is very important, ultimately it would objectively at the child's position.
Oh, of course, it's not the be-all and end-all, and I obviously would say that the view of the father is not the be-all and end-all. So yes, but it's a factor to be weighed into the balance. So G is a child who will have to contend with difficult circumstances, but not an especially vulnerable child, in the care of a competent, robust and protective mother. G's age is protective for the time being. That was conceded in terms. So it was well within the court's remit on that evaluative exercise to conclude that the potential impact or interference with G's Article 8 rights would be substantially less than Mr. Clayton contended for on behalf of the father. So those evaluative conclusions, I respectfully submit, are, and I say with all, I'm stuck with those. As regards public interest, there has been a tendency to, as I've indicated, to minimise the nature of public interest in this case. I'm not going to rehearse what it is, it's all set out in the but again, the judge considered those issues. She answered the question that Mr. Clayton had asked, paragraph 52 of his skeleton argument in July, page 279. How much public interest really is there in this case? It's basically the question he asked, and the judge said quite a lot. He is stuck with that evaluative conclusion. And I say it's really clear that the judge didn't give precedence to one right over the other. She self-directed quite properly about the test, in line with the approach the parties agreed she should take. She set out her reasoning clearly. She cited Ries, she cited Z8, she cited Conway. When it is said at round 3 that the judge gave precedence to Article 10, really what's being referred to is the fact that the judge didn't agree with the evaluation of the father. She thought Article 10 was more important than we contended for. She didn't think Article 8 was as weighty as the father would have her accept. On the question of proportionality, essentially, part of the parallel analysis is to be looking at, well, what's the least interference I can achieve in order to meet the needs of this particular right without impinging challenging more than I need to on some other opposing rights. Now, a lot of the groundwork had been done before we got to the point of the hearing denial because of the colour-coded judgment and the dialogue that had emerged, enabling most of the parties to whittle down what was really important and to agree this bit clearly shouldn't be published, leaving a hard run for the bits we were stuck on. And the bits we were stuck on were the names and the identity of the parents. And I just want to say this on proportionality. Looking at the question of correcting the public records of the matters contained concerning the father's conduct in the articles, that element of the public interest cannot be met at all without identifying the father. You can't correct a misleading impression person X has put into the public domain about person X's conduct without identifying person X. There's no lesser way of achieving a just outcome in relation to that particular element of public interest bar identifying person X. And so I have briefly read Cuja, but I don't pretend to have read it in any detail. But the point that stuck out when I scanned it this morning was that that case rehearses the familiar authority about what's in a name. Of course, part of the reason for the name is because it engages readers, and therefore it means that any public debate that's going to be had is likely to gain more traction. But it's not just that. In this particular case, you just can't correct the misleading impression. You can't say person X is same person in the judgment. And similarly, the points about men in positions of power and the particular position father held, that is in paragraph 16, etc., that cannot be met at all without identifying wrongs, without identifying father. Can't correct a misleading, and you can't, there isn't a lesser way of meeting that particular element of public interest without the identification, without publication of the paragraph 16 information. And you can't meet the Article 8 and 10 demands around the mother's rights to informational self-determination, the public interest in the media being able to tell the mother's own remarkable story about her journey as a victim of domestic abuse to where she is now, without naming the mother. And describing her current situation, I say briefly. There's no lesser way of achieving a just outcome in relation to that element. But nothing raised on appeal substantially changes, indeed changes at all, the evaluation of all those elements of public interest were really important, and nobody has suggested any other way that they could be met at all, bar identification. As regards rape and whether it's a special category, it's not. It's not in a special category at all. It's simply a type of domestic abuse, a particular method through which coercive and controlling behaviour is perpetrated. It's one of quite a large number of findings made in this case. I deal with this largely, paragraph 18 on it in a skeleton argument. I'm not going to rehearse that, but I will say this. In July, in his third skeleton argument, when shortly before the hearing before Mrs Justice Lieven, the father accepted there should be publication. Because before then he'd been saying no publication at all. He said that the court's note, that's paragraph 3, page 263. The father accepts that transparency requires all the adverse findings against him to be published. That's a proper concession that the rape findings were an integral part of the findings and not severable. It was also said that the slightly odd reference to publication warts and all that the father contended for in his first skeleton argument partly referred to a mistaken belief or a mistaken interpretation of the colour code of judgment, in that the father had thought that Miss Tickle wanted to redact those parts of the judgment which explained the legal process and the standard of burden of proof, i.e. the civil standard of proof. There had never been any intention to redact that information, and it was therefore agreed, once this conclusion became clear, that to the extent the judgment was published, all that analysis properly explained the approach the judge had taken, including the fact that any rape finding was only on the civil standard, should be incorporated into the judgment. Mr. Clayton can't now say on behalf of his client that rape findings are in a special category on that basis. They're not. And they can't be cropped, because they are integral to the judgment. And they shouldn't be cropped either, because they do hold particular public interest. On section 97, the proper place to argue this point was at first instance. We had a day and a half of time. Mr. Clayton says this morning, well, the reason it wasn't raised was because it wasn't argued by Miss Tickle. The reason it wasn't argued by Miss Tickle was because we made a straightforward proposition in our skeleton argument, paragraph 12, page 235 of the bundle, that the appropriate authority was Webster, and that the court had to adopt a convention compliant interpretation of section 97.4. And paragraph 63 of the replying skeleton, page 284 of the Lordships and Ladyships bundle, has conceded in terms. We agree. So there wasn't any further argument, because there wasn't any argument to be had. Nobody suggested section 97.4 represented a bar to the court making the decision it made if, having evaluated matters under re-ex, the balance fell down in favour of publication. Nobody said you can only do this if it's positively in the interest of the child and the child's welfare requires it. That's why I didn't make any arguments to that point, because it wasn't in contention.
That must be the argument, mustn't it? That either that section 97 applies,
Yeah.
and therefore Articles 10 and 8 have absolutely nothing to do with this case at all, and unless a strict interpretation, a non-Webster interpretation of 97.4 is applied to the case.
Yeah. I'll come to the merits of it, but basically you can't
But
have
I mean,
both.
that's the structure. I'm not talking about the merits at the moment, but that must be the argument,
Yeah.
wasn't it? And that simply wasn't the approach of the court. That wasn't.
It wasn't the approach. It wasn't the approach the court was invited to take. So just before I move on to the merits, in terms of the prejudice points and why this argument should be put back in its box, there were whole sections in the skeleton arguments below on deferred publication, postponement. Because at the time, certainly at the time when I wrote the first skeleton argument, we had no idea whether proceedings were about to conclude or not. Didn't know the landscape. Those were not dealt with, again, because nobody was saying, well, you might be able to publish, but not now. Nobody said timing was an issue. Nobody said section 97 was an issue. Had we known that it was contended that section 97.4 represented a block on the court carrying out the re-ex exercise, we would have argued, firstly, no it doesn't, because Webster's right, and secondly, we would have said that even if we're wrong, can you consider our alternative arguments about postponement? None of that was pursued. It wasn't pursued because it wasn't necessary.
Can we just look at the commission decision
Yes.
briefly?
It's at page
316.
362. 362. And I suppose what I say about the wording of the Commission decision is this, that it's, first of all, there is a clear but generalised indication that the court took the view at that stage the appeal in the round had a limited prospect of success. And it appears that permission was given on a generalised basis in order to facilitate what the court wished to do so, to review principles around transparency, public interest and domestic abuse in particular. So it was granted on the second ring, on the plea ring. What hasn't been addressed, and I accept it's ambiguous, is which specific grounds were given permission and which specific grounds weren't. But nonetheless, to make the point, as a matter of broad procedural fairness, all parties, the points that are run and conceded, as was the Ries argument, and points that are not run at all because they've been conceded before there's even any argument, section 97, should not simply be raised again on appeal, particularly where they mean that somebody has proceeded through a hearing on a false basis effectively, and the arguments are going to have to be rerun.
Well, it has an impact, doesn't it, on the interests of the litigants? Because courts exist to decide matters that are in issue between the parties.
And section 97 point was not an issue between the parties.
I'm just trying to see. I mean,
This happened in Almac too, didn't it?
So sorry.
This happened in Almac too. There was an attempt to resurrect or to bring up the first time by amendment the grounds of appeal.
Yes, and in that case, to be fair, as your lordship indicates, the grounds of appeal were issued, if I understand the judgment correctly, and then following issue of the appeal, somebody said, said, actually we'd like to have this ground. This is
Yes,
slightly different.
it is different.
It
Depends on how one analyses the grant of permission in this case.
It does.
Because what it doesn't say, explicitly anyway, is that any of the grounds are arguable.
No, it doesn't say that.
I mean, what is your bottom line on this?
My bottom line is it's not arguable, and I'll come on to that. That's the more appropriate way to do it.
But what is not arguable?
The section 97 point,
Yes.
i.e. that Mr Justice Lieven's name was in Webster, in indicating that the court had to give, could give, a convention compliant interpretation, section 97.
But I'm sorry, I think again my fault, but I was asking for the bottom line on the permission issue because I'm looking at the. Of course, we're not bound by the way in which permission was given in this sort of issue, in this sort of context, but you will see what's said in the penultimate sentence. And what I would like you to do is to tell us what your view is, your submission is in relation to that.
As regards the
And the implications for the issues we should decide on this appeal.
well, my lady, my primary submission is that this is not an issue that the court should be dealing with. But if the court is going to deal with the issue, then my submission is that it should, for reasons which I will expand upon, affirm the decisions of the court in both Clayton and Webster. That's correct. And if that is correct, then of course the section 97 point, as it relates to this case, falls away. We're back to Webster. And I can expand on why I say that. The last point I would make in relation to permission, I don't want to trouble the court anymore on it, is that where it is said there is cross protection, I just don't understand that. The father is Eunice's counsel and working pro bono. There is no cross protection. Every day Miss Tickle is working on this case, she is suffering a financial loss. She's not being paid. So on the merits of section 97, I deal with it in my skeleton argument at, I've written down 83, I'm not sure if I'm in paragraph or page. I mean, paragraph 68 onwards. As before I launch into the full-on merits of section 97, I just want to deal with identification. Round 1, which Mr. Clayton has touched on quite briefly this morning, which is that element of the appeal relating to identification of G, draws no distinction between direct and indirect information. Mr. Farmer gives in his skeleton argument actually a really good summary that I want to borrow, page 109. He says, paragraph 6, obviously the judgment and reports will create the risk of jigsaw identification. Ms. Tickle and I have been aware of that from the start. We've done all we can to limit the risk, minimise any risk of harm, etc. And he goes on a bit further down, perhaps 6 or 7 lines down. I argued, means I argued below, that there were shades of identification. We will not name the child, publish a photograph, or give a sex or age, and I think saying publication will inevitably identify is too simplistic. And he goes on, Mr. Farmer, to explore the types of people who may already know who G is and who may, through locality or other social connections, know who G is by virtue of knowing their parents. So all I want to say on that ground really is that there are shades of identification, as Mr. Farmer says, and I take ground 1 no further. Because this was never a case about direct identification of the child, it was a case about there is no other way to make a public interest without identifying the parents. As regards section 97's limited effect in terms of it only subsisting for so long as the proceedings subsist, my Lady Justice King has that point. The relevance of the time-limited nature of section 97 as a whole is that it affords particular protection, and it reflects the fact that Parliament thought that children generally needed particular protection whilst proceedings were live. So there is an Article 6 Administration of Justice element to section 97. But in the Al Maktoum case, publication of findings in an interim stage was not part of publication. And in this case, nobody said, well, you have to wait to the end of proceedings because it's going to affect how these proceedings run. The findings themselves, as was said in Al Maktoum, they were fine. That part of the case, the line had been drawn under it. The court would go on and work out what to do with those findings and what decisions to make with G. But the Article 6 rights of the parents as regards the determination of those factual disputes, that was done. There's no appeal, notwithstanding what is said about the findings in the skeleton argument. There has been no challenge. Those findings stand and will stand. So this is not a case where section 97 needed to remain in place or where there was a justification for leaving it in place because of anything connected to the fact that proceedings were ongoing. It might be in some cases, but it wasn't in this one. And the other point on timing, of course, is the age of G, which is a protective factor. It won't be a protective factor forever. We don't know how long the proceedings are going to continue for, but there is clearly a spectrum. It's clear that Mrs Justice Lieven didn't anticipate that the position would materially change in the short term. But as a point of principle, timing does matter in terms of the age of the child, because the broad thrust of what this judge concluded about this child was that if it was going to happen, it would have to happen sooner rather than later. She says expressly in her judgment that had G been a much older child, substantially older child, the balance might have fallen differently. So I just asked this hypothetical question really. How can it be right that the court is, as Mr. Clayton I think contends, is precluded from making an order now, but it could make it whenever it is the proceedings end, whether it's in 6 weeks or 6 months or 6 years. When the RIAS evaluation tells us if it's going to be published, it's better for G to do it sooner rather than later. How can that be right?
Well, on that question, I think it's probably a convenient time for us to rise.
It is. Thank you.
All rise.
Thank you.